Dominique Ray was sentenced to death for the 1995 rape and murder of a 15-year-old girl. Tiffany Harville disappeared from her Selma home on July 15, 1995, and her decomposing body was found 1 month later in a cotton field. Ray was convicted in 1999 after another man, Marcus Odin, confessed to his role in the crime and implicated Ray. Odin told police that they had picked the girl up for a night out on the town and then raped her. Odin said that Ray cut the girl's throat. Odin pleaded guilty to murder, testified against Ray, and is serving a life sentence without parole. On the morning of July 29, 1999, 12 men and women filed into the jury box in the Dallas County Courthouse in Selma, Alabama. The day before, they had convicted Dominique Ray of raping and killing a 15-year-old girl in a cotton field outside of town. It had taken just an hour and 40 minutes to deliver their verdict. It was a terrible crime, and not the first killing Ray, 22, had been convicted of. 5.5 months earlier, Ray had been found guilty for his role in the murders of 2 teenage boys in Selma. Now, shortly after 9 a.m., the jury was set to hear testimony on whether Ray's life should be spared or if he should be sentenced to die. Juries in death penalty cases have been required to separately weigh questions of guilt and punishment for more than 4 decades. Those facing the possibility of death get to argue for mercy. They're allowed to present evidence that might temper a jury's willingness to recommend execution. A defendant's limited intelligence, for instance, or history of victimization. The obligation of defense lawyers in such cases, the U.S. Supreme Court has held, is considerable. William Whatley Jr. was Ray's lead defense lawyer in the Dallas County courtroom. Whatley was a former prosecutor, and this was not his first death penalty case as a defense lawyer. But he opted to let his co-counsel, Juliana Taylor, make the presentation to the jury. Taylor, just 3 years out of law school, had little experience. She'd never been the lead lawyer in a criminal trial. And she'd worked on just one capital case. Whatley and Taylor put a single witness on the stand, Ray's mother. She testified that she loved her son, and that his life had not been easy. His father, she said, had disowned him, and she had tried her best. The testimony lasted roughly 10 minutes. The jury, after 2 hours of deliberation, voted that Ray be sentenced to death. In the 2 decades since the jury's decision, lawyers for Ray have mounted appeals in both state and federal court, insisting he deserves a new trial. They have alleged that Whatley failed to adequately represent Ray. They have alleged that prosecutors withheld evidence of other suspects in the murder of the young girl. They have argued that members of the jury knew a police detective involved in the case and should have been kept off the panel. Most recently, in an appeal still making its way through the Alabama courts, the lawyers have argued that the state withheld critical evidence involving Ray's chief accuser, his alleged accomplice in the murders. The lawyers have asserted that Marcus Odin, who confessed to the 3 killings, had been suffering from schizophrenia when he testified, and that prosecutors withheld that fact from Ray's defense team. Prosecutors have denied the claims of misconduct, and they have prevailed in each of Ray's appeals. but the question of whether Ray was adequately represented during the penalty phase of his trial has shadowed the case almost from the time the jury returned its verdict for death. In appeals filed in state and federal court beginning in 2003, Ray's lawyers have attacked Whatley's performance, saying it failed to meet the constitutional standard required of defense lawyers in such proceedings. Whatley failed to hire an investigator to explore Ray's background. He withdrew a request to have Ray evaluated by a forensic neuropsychologist. There were family members who said they would have been willing to testify, but they were not found, much less put on the stand. School records weren't researched, nor were records chronicling Ray's experience in foster care. Ray was sentenced to death by a jury and judge who simply had no idea of who Ray actually is and how he came to be a defendant in a capital case. 2011 federal petition for habeas corpus. Whatley and Taylor prepared virtually no mitigation case at all, making it all but certain that jurors would recommend the death penalty. In their filings, Ray's lawyers have laid out the details of what they say was a horrifying upbringing for a boy with an 80 IQ. Ray, 17 at the time of the first murders, had been bitten as he went from household to household from the age of 3 on, bouncing between Selma, Chicago, New York, Philadelphia, Virginia and South Carolina. After being left in an abandoned building in Chicago, he'd been taken in by state child welfare officials. He was then sent off to suffer more, sexually abused by his stepmother's family as a toddler, and encouraged by his mother to have sex with her friends when he was a teenager. He never made it past 8th grade. He's since been diagnosed with schizophrenia personality disorder, characterized by severe social anxiety, paranoia and unusual beliefs. Ray, 42, is the 64th inmate executed by the state of Alabama since 1976. In July, he was given a choice: to die by lethal injection or by inhaling deadly amounts of nitrogen, an untested method for execution. Ray, who years ago converted to Islam, said his faith would not allow him to play a role in his own death, and so he is scheduled to be killed by lethal injection, the state's standard method. Alabama uses a 3-drug combination, but the way they are actually administered is a closely guarded secret. In the past 2 years, there have been complications with a number of executions. Ronald B. Smith heaved and coughed for 13 of the 34 minutes it took to kill him, according to accounts of those who witnessed the execution. Ray said he had reconsidered and now was willing to be killed by what is called nitrogen hypoxia. The state in 2018 had given the option to all death row inmates but said they had to decide in a prescribed time period. 51 inmates opted for nitrogen hypoxia, recognizing that it will take years for Alabama to figure out how to carry out the untested method. Dominique Ray was 42 at the time of his execution. He was pronounced dead at 10:12 p.m. on February 7, 2019, of a lethal injection at the state prison in Atmore. Ray's execution attracted national attention. When Alabama refused to permit his imam to be present in the execution chamber in circumstances in which Christian prisoners were provided religious comfort by a Christian chaplain. However, Ray had also argued that he was innocent, and that the evidence against him was false and unreliable. Ray had argued Alabama's execution procedure favors Christian inmates, because a Christian chaplain employed by the prison typically remains in the execution chamber during a lethal injection. But the state would not let his imam be there in the room. Attorneys for the state said only prison employees are allowed in the chamber for security reasons. Ray's imam, Yusuf Mesnet, watched the execution from an adjoining witness room, after visiting with Ray over the past 2 days. There was no Christian chaplain in the chamber, a concession the state agreed to make. Strapped to a gurney in the death chamber, Ray was asked by the warden if he had any final words. The inmate said an Islamic statement of his faith in Arabic. Thank you for watching Death Row.